Chapter 3, the unauthorized practice of law. We spend quite a bit of time discussing UPL throughout this entire program, and so this is a concept that you've heard a lot and you're already familiar with. We do go into it in greater detail in this class, so it is important that you read this chapter and understand this concept as thoroughly as possible. As a paralegal, this is an area where UPL is a different issue for you than it is for attorneys. The other concepts we're talking about, such as confidentiality, it affects us all the same, but UPL is a little bit different for paralegals than it is for attorneys. So it is possible that when you enter the paralegal field, you may find yourself having a better understanding of UPL and how it affects you than the attorneys do. So it is really important that that you are comfortable with this concept and understand where the boundaries are and when to ask questions of your supervising attorney should you have any concerns. So how this affects attorneys is basically, as long as we are licensed to practice law and we are talking to our client about their case, we don't have a UPL issue. The only time we really have a UPL issue is if we are giving legal advice to someone who is not our client. But if they're our client, we've entered into the attorney-client retainer agreement, we can discuss their case with them all we want. Obviously, as a paralegal, you cannot give legal advice and you cannot discuss a case with the client unless you have been authorized to do so by the attorney. And so it's much more limiting for you as a paralegal than it is for an attorney. And I will be completely honest, although we learn all of these ethical rules in law school, I don't think we do a good enough job in our law schools ensuring that attorneys understand how these rules affect other people who work in the law firm. I think the focus is very much how they affect us personally, but not how they necessarily affect those that may be working with us and those that we may be supervising. So it is something where you need to make sure you are really clear on these concepts, because should an issue arise where you have engaged in UPL, not only can it have repercussions for you personally as an employee, it could have repercussions for the attorney, and of course our main concern is our clients. And so we want to make sure that we never put ourselves in a situation to have to deal with that. So first, why we are so concerned with UPL. I mean, obviously we know we are not supposed to engage in the unauthorized practice of law. We can only engage in the practice of law if we are in fact a licensed attorney. But why are we so concerned about it? One of the first reasons that we are concerned about the concept of UPL is that when a person is licensed to practice law, it tells the client that the attorney has a certain level of competency, and the client, in theory, should feel very comfortable that the attorney knows what they're doing and can represent them to the best of his or her ability. Also, the fact that attorneys are licensed allows for a level of accountability. If an attorney engages in any sort of ethical wrongdoing, a client can file an ethical complaint against them. We've already talked about that. Again, as a reminder, you can go to the Pennsylvania Disciplinary Board website to find out more information about the procedures and the complaint form. But there is a way for attorneys to be held accountable, and there's a way for clients to try to ensure that attorneys are held accountable. If someone who is not an attorney is engaging in the practice of law and is giving legal advice, there is no clear way of holding them accountable. You can't file a disciplinary complaint against them because they're not licensed, so you have to go through the court system. That's not an easy thing for a client to do. It costs them money, it costs them time. The burden falls on the client to pursue it, and that's not ideally how it should work. So both competency and accountability are huge factors when you're dealing with this unauthorized practice of law prohibition for non-attorneys. So the next question then is, what is considered the practice of law? So the textbook gives us three definitions. The definition that Pennsylvania uses is also in the In re Stone case, so please pay attention to that case when you're doing your case brief because the rule is in there. I will say you need to be aware of this test and you need to understand it, but even understanding the test doesn't necessarily make it easy to apply in a practical setting. But let's take a look at them. So, practice of law. The first test, professional judgment test. This is the one Pennsylvania uses. This is the one cited in the In re Stone case. This test basically asks the question, does the activity require legal knowledge, training, skill, and ability beyond that possessed by the average lay person? So, does the activity require legal knowledge, training, skill, and ability beyond that possessed by the average lay person? Okay, now one thing to keep in mind, you are not the average lay person. You have legal training and knowledge. So you can't just go by, do I know how to do this? And if so, then I can go ahead and engage in the activity. You are not the average person. So the average lay person is someone without legal training. And so if the activity requires somebody or some level of knowledge, training, skill, and ability above what that average lay person has, then it's considered to be the practice of law. The next test, and this is not the test that Pennsylvania follows, is the traditional areas of practice test, which asks the question, is this activity normally one that would be performed by an attorney or normally understood to be the practice of law? So like the first test, it gives us some idea of what the practice of law is, but it's not necessarily clear cut in any particular situation what might fall under that. And the third test is a good one to keep in mind because I think this one is applicable to some situations, and that's the incidental legal services test. And that's asking the question, is the activity legal in nature or is it a law-related activity of a regular business routine? So the most common example is you're filling out a document for a bank loan. So you're sitting there with the loan officer and you're filling this out and they're giving you information and you may be asking them questions and they're answering those questions related to this form. You're basically entering into a contract and they are giving you some information that could be construed as legal advice, but their business is giving loans, and this document that you have to fill out is just part of that larger business. And so it would not be considered the practice of law. And so if you look at that situation with the first test, the professional judgment test, you would say, no, applying that professional judgment test, that would not be considered the practice of law because filling out a document for a loan does not require any specialized skill, training, or education beyond what an average layperson has. So those are the three different tests. And again, the professional judgment test is the one that we're going to be paying close attention to in Pennsylvania and in this class. Now, Pennsylvania does have a statute for the unauthorized practice of law, and this is a criminal statute. And within the past couple of years, I've looked it up to see if there's any case law underneath it. And there really isn't anything dealing with paralegals or non-attorneys. So I don't know how often this statute gets used. Clearly, there's not published cases, appellate court cases dealing with it, but it does give us some guidance. But this is criminal. It is not the ethical rule. This is something in addition to the ethical rules that we are going to be looking at. So basically, under Part A, the general rule, what you really want to pay attention to is the fact that in Pennsylvania, any person, including a paralegal, who practices law or who holds him or herself out to the public is being entitled to practice law, or using or advertising the title of lawyer, attorney, attorney at law, counselor, or any language that would give an individual the impression that the person is an attorney. And if they do that in any way that the person believes that they are in fact an attorney, if they are not in fact an attorney, that is a violation of this statute. And so the statute is very clear that it is a violation of the statute if a person practices law or holds themselves out or uses language that gives others the impression that they're entitled to practice law in the state. Now, it is a misdemeanor of the third degree for the first violation. Any second or subsequent violation is a misdemeanor of the first degree. So it never gets out of the misdemeanor area in terms of penalty. When it gets into practice by association, so this would be law firms, that type of thing. It basically is just clarifying that a law firm can employ people who are not attorneys. And so if you look specifically in section B2 that's listed there, it's very clear that this section is not to be interpreted to preclude the use of non-attorneys in the practice. And so basically the attorneys can hire non-attorneys to assist them as long as they are performing their employment under the direct supervision and control of a person who is entitled to practice law in the state. And so it is very clear that this does not prohibit the employment of paralegals or any other non-attorneys. Then the last part of the statute is an injunction. So this might be the better part or the best part of this statute, that if a person is found to have been engaging in the unauthorized practice of law, they can be enjoined from engaging in that activity from by the court if they are brought before the court, and that's probably the most effective tool. I'm charging someone with a misdemeanor, it's kind of a slap on the hand potentially, but getting a court order saying you must stop this particular activity certainly can have a little more teeth in it. In the case that you are briefing in Ray Stone, that the court does issue an injunction against the party in that case, and then when they violate that initial order, they're brought back in for contempt. And so that might be the part of the statute that is the most beneficial. So that's the beginning information regarding the practice of law, keeping in mind that knowing we have a statute, knowing we have this professional judgment test, it still gives us a lot of gray area in what is the practice of law. So what we're going to be discussing in class are some of the specific activities that are considered the practice of law, including giving legal advice. And so we will go more detail as we discuss this in class.